Welcome to Dorsey and Whitney's webinar on Do You Know Your ABCs? Assignments for the Benefit of Creditors, a lesser-known bankruptcy alternative. I'd like to introduce Nick Vlitra, a partner in Dorsey's Finance and Restructuring Group. Nick?
Thanks, Matt. Good afternoon, everyone. I'm Nick Vlitra, and welcome and thank you for joining us for this month's meeting of Dorsey and Whitney's Bank Counsel Roundtable. The panel has prepared a presentation that it's called Do You Know Your ABCs? Assignments for the Benefit of Creditors, a lesser-known bankruptcy alternative. Our speakers today are Dorsey lawyers Joe Acosta, Alessandra Glorioso, Gabriel Hartsell, and Matt Olson, all of whom I will introduce in a moment. But first, a couple of housekeeping details to go over. First, today's program is scheduled for 60 minutes. The materials for the presentation, as well as the attendance form, are available for download through the reminder email that went out to registrants yesterday from events@dorsey.com. Links to the attendance form and materials will also be provided to you via the chat during today's presentation. The CLE code, for those who need it, will be announced by our panel and then will also be noted in the chat. You should send your completed attendance form to attendance@dorsey.com. Certificates of attendance will be sent to those who return the completed form. Today's PowerPoint deck will also be accessible via a link that will be included in a survey email that we will send out to you after today's roundtable. We will not have a Q&A during or after this presentation. If you do have a question for our speakers, you're welcome to contact them directly or through your usual Dorsey contact. The speaker's contact information can be found in the presentation materials along with their bios. Okay, with that out of the way, let me introduce today's panel. Joe Acosta is a partner in Dorsey's Finance and Restructuring Group and is located in the firm's Dallas office. Alessandra Glorioso is a partner in Dorsey's Finance and Restructuring Practice Group. She is based in Dorsey's Wilmington, Delaware office. Gabriel Hartsell is also a partner in Dorsey's Finance and Restructuring Group, and he works out of Dorsey's Phoenix office. And Matt Olson is of counsel to the firm and is a member of the Finance and Restructuring Practice Group. Matt is based in Dorsey's Palo Alto office. Additional biographical information on our speakers is included at the end of your materials and on our website, as is their contact information. Okay, with that, I hand you over to Joe Acosta. Thanks, Joe.
Thank you, Nick. Hello, everyone. My name is Joe Acosta. As Nick mentioned, I'm in the Dallas office in Dorsey. My fellow panelists and I hope to cover these areas of ABCs, what they are, when they could be used, what other options people have, and when they're not desirable, and give you some key insights as to this alternative that's been around for a while. Next panel. So what are ABCs? An ABC, as Nick mentioned, is an assignment for the benefit of creditors. It's essentially a liquidation proceeding. When you sell all of the business's assets, it could also be a liquidation proceeding for an individual. But at the very end of the day, the business is not going to go, the business is going to go away. You're essentially selling all the assets and there's nothing else for the business to do. Generally, it's non-exempt assets, and state law governs what exempt and non-exempt are. There's certain assets that are protected from creditors, but when you assign it, you assign primarily, basically all of the assets that the company owns or the individual owns to the assignee. It's an alternative to, people are more familiar with bankruptcy as a in-court proceeding or receivership as an in-court proceeding. An assignment's less formal than in-court proceedings. It doesn't require a lot of court supervision generally. Sometimes, in some jurisdictions, there is some minimal court supervision, but it's not as heavily regulated as an in-court proceeding in bankruptcy or receivership. And then it's a little more formal than just you having a garage sale or selling your assets by yourself. It provides a little structure. It gives you a little more benefit than just liquidating without a statute or some common law in place. It's been a procedure that's been around for hundreds of years. It's not as well used, but it's recognized in most states through either common law or statutory provisions that are sometimes very specific and sometimes not as specific, just depending on the jurisdiction.
So I'll jump in here and we'll talk about a little bit about popularity of ABCs. I'm sure many of you who practice in or connected to California or Delaware, particularly Delaware companies, have seen an ABC at some point. The regimes are relatively friendly in both California and Delaware. California is a completely out of court process. There's very light, surprisingly, some may say, very light sort of statutory context for an ABC in California. Delaware has a little bit more. It's an in-court process. And we are starting to see ABCs gain some ground in other states as the expense of bankruptcy continues to grow. Unsurprisingly, venture capitalists have tended to favor ABCs because of their relatively low profile and ability to sort of quickly and the flexibility of resolving situations through an assignment process. I'm not sure if anyone else wants to chime in about state-specific issues. Alessandra, if you have thoughts on Delaware or...
Sure. So, if there was some statistic of the number of ABCs out there in the United States, you would see by far the most are probably in California, because it has a super friendly regime that doesn't require in-court administration, and also Delaware, because Delaware is the place of formation for so many organizations. It has a statute that's been around for about ever, and if you want to read it, you'll see that it sure is old, but it does require sort of not overly cumbersome requirements, only a handful of key filings, and there's room for flexibility there. So it is friendly, and it's also a process that's overseen by Delaware's Court of Chancery. So that's one of the most preeminent and credible courts in the country. So if you want to have backing and showing creditors and other stakeholders that the assignee is doing its job and is being overseen, you have a real benefit in having it overseen by the Court of Chancery. Also, people in Delaware have been doing ABCs for a long time, so there is a decent amount of familiarity amongst advisors, counselors, attorneys, and the court with the process.
Great. Joe, do you want to give just a quick thumbnail on Texas ABCs?
Yeah. Well, there's no question that states like California and Delaware have pioneered this tool and established a mechanism or some structure on how to use it. Texas has actually had a statute on its books since the 1800s, as well as common law that also allows this device to be used in Texas. It's not as popular as in California or Delaware, but we've used it several times, and it's provided an efficient remedy for our clients. I don't know. What do you think, Gabe, about Arizona?
Yeah, it's interesting. Arizona is kind of in that middle ground, not the common law where you kind of outside of the court do everything through the ABC process, and you have some court oversight, but our statutory scheme is not very robust, and like all of the others, has been around for a while. It's 1955, I think, is the primary part of the scheme, has been there with some changes over the years, but not a lot. Not used a ton here, but it's there, and it provides, I think, a great opportunity for that winding down of a process and doing it quicker and outside of kind of the more heavily litigated bankruptcy route to do things.
Now, there are some high-profile cases, Matt, that you can draw on.
Yeah, I mean, we've talked about, or I mentioned, I think that ABCs can be lower profile, certainly lower profile than a bankruptcy filing would be in California, because there's no bankruptcy docket for them to go poke their fingers through. but they're still used in high profile sorts of situations. The sort of most relevant example right now is the Theranos case. Theranos, when that sort of created several years ago, the assets there were transferred to an assignee for benefit of creditors. That assignment process is in fact ongoing, still reconciling claims and trying to recover on some assets. Fast was a fintech company that in the first quarter was kind of sort of a high-flying one-touch payment processing overlay for one of the popular fintech processors. They kind of very quickly ran out of operating capital, and that very promptly went into an assignment process. That one is interesting because it had a very public sort of wind up where it became very clear that the company was in trouble and there were massive layoffs. But then once it was into the assignment process, there wasn't a lot of media attention paid to the case. And I think that's probably what the stakeholders in that proceeding wanted. And then Coldwater Creek, which is a clothier, that was a Delaware ABC. That actually, I think, as I understand Alessandra right, that was a group of companies that went through one sort of assignment.
Right. And if people are looking at that title saying, hey, wasn't that a bankruptcy? You're right. It was a bankruptcy. And the buyer who bought the assets out of the bankruptcy developed or started a few different entities to use those assets and ended up putting them all into an assignment for the benefit of creditors. So that's one where they sold the IP within the assignment process. And you can go to Coldwater Creek's website now and look at their spring fashion and see how this asset has actually, the IP has been functional, right, through a bankruptcy, an assignment for the benefit of creditors, and now is on to its third known IP buyer in a pretty short amount of time.
Great. Well, I'm gonna turn things over to Gabriel to talk a minute about how this process actually works.
Yeah, thanks, Matt. So the question is, how do we do this, and what's the process? And as you've heard, there are sort of different states and different schemes. It's a state process that's done, and it's run either via common law or via statute that's established in each of the states. But generally, it follows kind of the same key aspects across all of the states, and wherever you're doing one, you'll have a lot of the same characteristics of the assignment process. Typically, the first thing you do, you've got to have the debtor, right, or the company, the assignor on board and approving the process to go through. That's done. The debtor's board, they consent, the stockholders consent to going through the process. There's a resolution that's completed, and that kind of gets the ball rolling. One of the big things with ABCs is you are working with other creditors, right? The major creditors, the secured lender that's got the blanket lien on all collateral, are the biggest creditors in of the company. Those are the ones that are typically pushing the process somewhat and working directly with the debtor to, okay, here's what we're going to do. And they're consenting to the assignment process. As I'll mention later on, any creditor that wants to participate has to consent to the process. I think there might be some differences in different states, depending on if the creditor consents or not, and how that impacts discharge of the debtor or the assignor after the fact. In Arizona, where I practice, only the consenting creditors participate in the assignment, meaning only the consenting creditors take payment from the process, and only the consenting creditors are discharging the debtor. And so just something to keep in mind. But so you essentially get that resolution, you move forward, you work with the major secured creditor, and in that process, in the consent that secured creditor gives for the ABC to move forward, it has some power to control kind of what it's doing and what's being sold and how the assignee is running the ABC. Some of the things that they put in it, conditions on sales of its assets and the collateral that's being used, minimum purchase price, having lender consent for the actual sale. And again, because this is friendly in the extent that the debtors working together with this creditor, that's how you get those things into the lender consent or the assignment, and ultimately assignment that's going to assign the assets to the third party that comes in to take them and market them and sell them. Bear in mind the expenses of these assignments, those costs, the cost of the third party to come in and to market and sell, the reasonable costs, those are recoverable and paid out of the estate, meaning the funds that are recovered from the sale of the assets, they're typically paid first from the recovered money that's brought in from any of the sales. Other stuff that will go into that, and we'll talk about the cost of an ABC later on, but some of the other things that are covered are attorney's fees. When you have other consultants that come in, those types of fees are also covered as those administrative expenses. So you've got the secured lender on board, the main consent, you've got the debtor, and you move forward. So now you got to prepare the assignment deed. And essentially, as has been mentioned, all of the assets that are not exempt of the debtor are being transferred over to the assignee to take and to market and to obtain the highest value at a sale as possible in order to maximize the recoveries that can be distributed to the creditors that are consenting to the ABC. So you have the assignment transfers the assets, and then it's depending on state, right? So if you have a common law assignment, say California, you're not filing in the court, you're just going through with the assignment, and you start the process of forming your LLC, say the third party, the assignee that's coming in, the LLC is formed and they take over the assets and they start the assignment process, the notice for claims, they do this. In other states, say like in Arizona, you first got to file your assignment in the court and post a bond. You post the bond, essentially is done. It's the assignee bond, and it's to protect, to ensure that the assignee is performing its duties in accordance with the statutes, and then also that it's distributing funds to each of the consenting creditors in proportion to their debts. And so it can vary. The court has to approve that bond, but that's the first kind of step in a statutory scheme state. You move from that, you get the bond set, you have the assignment. Now you got to give notice, right? And so you have a notice of assignment that's typically recorded in the local business newspaper where the debtor's located, and you send out a notice of this assignment, the ABC, to all of the creditors, all the known creditors. You've got a list, the assignee goes through and puts that together and gives notice. The notice sets out claim deadlines. Each state's different. In Arizona, you've got 4 months to file a consent to the ABC, and then 6 months from the filing or the notice, the publication of the notice, to file your statement of claim to the assignee. And so that's a Arizona process. Different states are going to have different timing of that, or what you set out, say in California with the common law, you'll set out a notice process and the timing for the parties to make claims. And so at the same time that claim notice process is done, you put out the notice. After the assignment's made to the assignee's in the gathering the assets, getting the debtors, all of the assets that were transferred, making sure that it's preserving the assets and continuing to maintain the value so that when the sale and the time comes, the best and highest value for those assets can be recovered. Again, maximizing the potential recovery and distributions to the creditors. So you've sent out the notices. Next is receiving the consents and essentially the statements of claim for each of the creditors. The assignee has a process for that. It'll be part of the notice that's out there. Different states are going to have different schemes for what is and what is not valid. In Arizona, if a creditor files a claim, a statement of claim, and consents to the assignment, it's considered valid. It's assumed to be a valid claim, and the assignee will pay out its proportional share based on that statement of claim. It's not to say those claims can't be contested. In most places, there's a process, in most jurisdictions, a process to contest other creditors' claims during the ABC process. The assignor debtor can come in and say, that's not a valid claim, it's not correct amount, and they would file an action. In Arizona, for example, they'd file an action to contest that. The same thing goes for any other creditor could come in and say, I'm contesting another creditor's claim, and you can file an action on that. It's worth noting, typically, because of the nature of the ABC, you're generally trying to work with the other creditors and all of the creditors, the ones that are consenting to this, typically having them come in and to avoid the litigation cost and not get into that scenario where you're having to fight a contested claim, or, and I say you, meaning the assignee, and it's eating away costs of the estate. And so part of that, having counsel, and I'll talk about this later on, having counsel available there to help work through and navigate some of those issues is one of the benefits of being able to go through this in the out-of-court common law and in-court statutory scheme. So you've made the claim process, you've set up the claim process, now you've gone through, you've marketed and conducted sales. You're starting to bring in funds from the sale of the assets. And so as part of that, once you recover a certain amount, and in different states will have different things, and different jurisdictions will determine when a distribution has to be made. In Arizona, once you have 10% of the recoverable assets or of the proportionate share of creditors' debts, you can make a payment. The assignee can make a payment on the amounts outstanding and a distribution to the creditors. Different states are going to have different timings and sort of triggers for that payment to be made. So you make the payment, you process the funds, and next, in a state statutory court kind of governed, you finish up the process, right? You've sold the assets, you've paid out claims. Now, what do? We take the funds, anything that's left after the consenting creditors have been paid their proportionate share. Those funds are then, in Arizona, for example, were put into the court registry, and you file a final report. You ask the court to basically approve the process, approve the payments, approve the assignee's fees, and discharge the assignor. And at that point, the company's wound down. The court approves the final report, discharges the assignee, and the assignor debtor company is wound down. Any remaining funds are put in the court registry, and non-consenting creditors can come seek to obtain those funds, and based on what's there and their shares of them. But that essentially wraps up the assignment process.
Sorry,
yeah.
Gabe, I just want to get a word in about, you've previewed a couple of times that every state does this differently, might have a different statutory regime. I want to also note that some states might have, on some of these topics, no statutory regime at all, leaving the assignee to run the claims process as it sees fit, make timing distributions in different timings, and deposit the proceeds in accounts of its choice. And there's not necessarily a requirement to deposit stuff with any certain entity or organization. So there's a lot of flexibility depending on what jurisdiction is available for an assignor. And just to point everyone's attention to or awareness to the annex of our slides, we actually have some state-specific information and nuance if people are interested in seeing the variations. We've covered the states where we all practice, as well as Minnesota, because of course it's Dorsey, and we know lots of you are probably in Minnesota. So sorry to jump in there, Gabe, go ahead.
No, thanks, Alessandra. Absolutely. I think that's you're exactly right. The flexibility. I mean, that's one of the biggest advantages that I see with the ABCs is that flexibility. And even in statutory regime states where you have requirements, there still is a lot of flexibility there.
And before we move on to the timeline, Gabe or Alessandra or Matt, what motivates the creditors to consent to the ABC?
Well, in California, the only consent that's required is the secured creditor's consent. Under California law, if you want to participate in a distribution from the assignment estate, you have to file a claim, but there's no other consent required from unsecured creditors. There's also
So if
no
they don't
discharge.
consent, they receive zero.
Well, no, in California, if you don't file a claim, you receive zero. The statutory, the regime here in California, the only consent that's required is that of a secured creditor because you're selling their collateral through the process. But there's no discharge in California either. I mean, we can think a little later, we'll get into some of the quirks there, but in California, we don't rely on unsecured creditor consent. We rely on secured creditor consent.
So like in Texas, if you don't consent, you don't receive a distribution from the estate. Even if you file a claim, you have to consent to the assignment as well.
Right.
Which motivates a lot of people to consent.
Yeah.
When we're talking about unsecured creditors, not secured creditors. I just wanted to emphasize that because I would think that's a huge motivating factor for people. You give them notice, you say, okay, well, if you want to play the game, you got to, sign up for it. And that usually, I mean, that's a persuasive argument to get people to consent.
And people might be wondering what the recourse is for non-consenting creditors in states where consent is required to take a distribution.
So they're left with the surplus if there is any. And a lot of times there isn't any surplus. So,
So it works like a subordination, right?
Yeah. So it's, if you want to increase the chances of receiving a recovery from the estate, then you consent. So that's one motivation why people would consent in those states where you're required to obtain consent. Texas is one of them.
Right. Yeah. And Joe, same goes here in Arizona. The consenting creditors are the only creditors entitled to any distribution from money that comes in. Non-consenting creditors, what do? Right. They're left to try to garnish any funds that are left after the distributions are made to consenting creditors. And so I think you're exactly right. This is why you generally are able to sort of pull together parties and push it through because the best chance of getting paid something is consent and work through it. So moving just quick to the timing, each state is going to be somewhat different depending on how much they've got to do with filings and what the statutes require. Generally speaking, you're looking at about a year. Certainly it can be shorter. You have statutory timing. And the reason that is, if you have a claims process that say is set up for 4 months to file your consents, and then you have 6 months to file the statement of claim from the filing or the notice and publication of the assignment, and you have a slight period of time after that to contest any claims, you're at 8 months essentially there, and then you've got to get the final discharge and report in a statutory court like here in Arizona. Other states where you can set up and structure the claim process however you want, the timing can change. You can get them done, a little bit quicker. And frankly, the asset type is going to depend on how long, right? What asset are you marketing? How long is it going to take to market and sell the assets? And what's going to happen with those assets? Some examples here: illiquid earnouts from the asset sales, and how you administer that can push things along a little bit longer to extend the timeout. And that's on average, we're looking at about a year.
Yeah, and I want to add in that even though these things can be start to finish in a year or longer, I know that we have a lot of bank attorneys here who could be interested to know that at least in Delaware and I think in California, the assignee can go ahead and pay the secured creditor on its claim as soon as the proceeds come in the door, or the secured creditor. Well, we'll probably get into this at a different point, but the secured creditor can have an agreement and its consent for collateral use to get paid at a certain time from those sale proceeds and other conditions. So the reality for the secured creditor is you can kind of get in and get out of this process sooner. And there are a lot of assignees out there who are willing to do what they call a pre-pack assignment, which puts that sale right up front. Like, we're not going into an assignment, no one's executing the documents until we've got an idea that a buyer is lined up. And that way you can work it that the assignment and the sale are simultaneous or rapid succession. So that way it's really quick for secure recovery purposes. But the actual administration, winding down the practicalities of winding down a company and running the sales process could take longer. The advantages of using an assignment over some of the alternatives we'll go through, but we've listed these in kind of an order of strength here. You get to pick your fiduciary here, which is a good benefit for the creditors, for the company itself, for everyone involved. It lends to efficiency. You've got somebody who functions like an investment banker. You can pick somebody who has the industry expertise and vet people and all of that. And we'll compare apples, oranges, and whatever other kind of fruit later in terms of the insolvency options available to people, bankruptcy and such. But that's clear, a very clear advantage over Chapter 7 in particular. So that assignee's expertise aids in the recovery of value. They've got their contacts, they've got the hundreds of people to send their teasers to sell the assets. They're well versed and familiar with the process and with selling assets generally. Because assignees are usually from advisory firms, they've also got a deep bench of expertise around them. So they've got accounting departments, they've got people internally who have expertise in different industries who can help them out. The fiduciary role means that the assignee is tasked with obtaining the highest and best value for the assets, making those distributions, and that we don't have directors and officers, managers, doing that function, or importantly, lenders. So that's the big advantage over an Article 9 foreclosure, that the lender isn't taking on that vulnerability where other stakeholders are looking at it to see what it does and analyze its sale and scrutinize. That all falls to the assignee. And as we covered a little earlier, a lot of states require a bond. So that's the recourse that complainee creditors and shareholders can look to if they don't like what's going on. And there's the court process available to them. So states that have a required court administration process will have a forum for people to go ahead and speak up. In states that don't have that, people have to take on the onus and go ahead and sue somebody. And then there's the efficiency of the liquidation and the administration. Important note in that fourth bullet is that assignees have their own counsel. So they've got advice from people like us. We represent assignees as well as buyers of assets and lenders. So we know this from all the angles, and lawyers like us help the assignees. And the goal, of course, is to get to a sale. So assignees fees, and we have a slide on this later, are set up so that it's a initial fee plus a success fee. So they're very motivated to get to that success fee and get there efficiently. And so that's part of the motivation to do things like the pre-pack that we discussed earlier.
And Alessandra, let me ask you a question. These industry experts that we work with, that Dorsey works with, are they doing like an ABC once a year, or are they doing them all over the country twice a year?
That's a really good question. They are doing them day in, day out, and they've been doing them for years, decades. Some of the advisors that we work with have been in this industry since that .com bubble that we referenced earlier, and even before. So yeah, these are people who have been who don't just do this for a living, but actually have contributed to the rise of this option.
Yeah, and Alessandra, exactly. Running, I guess, kind of keeping going along there. That you mentioned the assistance of counsel, the assignees having counsel, like us, to assist them and represent them, knowing that the counsel can kind of serve as that mouthpiece for, or in between other stakeholders and creditors when they're coming in to help with some of those communications. When the claims are being made, if someone has got an issue, you have that counsel that can be that in between buffer for the assignee to help things continue to move along. If you do have someone that might be causing some noise about the process or the issues, they're there. They advise on the statutory process, ensuring that the requirements are all met, that the ABC is done correctly, so that it's held up, and that it proceeds to run down, dissolve, and run down the company, and have the assets come in to be distributed. As you mentioned, having these third party and fiduciaries that come in, they're knowledgeable, they can operate the companies, and they have the ability to operate with that stack of people that they work with in their companies. They do, I think, come in and are able to preserve, they recover the value that's out there, ensuring that if you have a business that's all right, if you have the principals that are assigning this over, you want to make sure that assignee is knowledgeable and is able to get it to that sale as quickly as possible. But in that interim period, they are there. They can do these transition service agreements to operate the companies until they transition into a new buyer. As you mentioned, the pre-packs, different ways to structure that of you found the buyer, it's going to sell, you complete the assignment, and then the sale of the assets happens. Obviously, sometimes the most knowledgeable people are the former employees. They can be hired on as consultants. The assignee can bring them on to assist in that continued operation until the sale occurs. If you're pulling up assets or you're trying to market and have a higher return on the sale, that's there. And the assignee is able to collect fees for those additional operating periods. And so that's why they're motivated and have an interest in doing it and operating the business to the best of their ability during that transition pre-sale period.
Yeah, and as you can imagine, because the recoveries come from the money that the sales bring in, we don't really, it's not ideal to have those additional fees for operating the business come from the assets. So a lot of times what happens is the purchaser will pick those up. So, you get to the sale as fast as possible and then work it into the sale agreements that the purchaser's got to pay for that fee for operating the business.
Well, I think that's a great segue to talk about the budget for a minute, because that's really an area where secured creditors in particular can really add some value and some oversight to the process, because again, assignments operate on consent. Whose consent's required varies by state, but it's always has to have consent. So here's where secured creditors, in consenting to the disposition of their collateral, you can exercise some control over the process by approving the budget. And we'll talk about a little later, what are the costs and what are the things you should expect in the budget. But that's a real key, I think, tool for secured creditors. Just remember also that the estate, because it's a separate legal entity from the assignor, from the debtor, it does have the ability to borrow funds for administration or operations, but again, those just typically go with some sort of consent from the secured creditor. Joe, do you want to talk about lien status?
Yeah, so besides what's already been said, one of the biggest advantages of having an ABC is the ability of the ABC to convince people that it needs to work with them. It convinces creditors that it needs to work with them. And this is a huge tool that makes this more attractive than, let's say, a garage sale where there's no structure. You just, you negotiate everything. This tool allows you to say that, let's say a creditor had already sued an assignor or a debtor, and they wanted to proceed. Well, If you assign it to the assignee doesn't assume the assignor's liability or the borrower's liability. It becomes essentially a first lien creditor, a lien creditor second to any existing liens that existed. But as to regular unsecured creditors, it hops in priority to them. And so they can't, enforcing a lawsuit against the assignor doesn't do them a lot of good. And they have to you can force them, strong arm them to participate in the process by telling them you're suing an entity that's no longer has any assets. And by the way, we didn't assume their assets. We're allowed under the statutory scheme or under common law to be assigned these assets without assuming the liabilities of any other of the assignor. So this is one of the benefits. This is one of the reasons why ABC can be attractive to persuade a large body of creditors, unsecured creditors, to cut it, to play ball, to cut a deal, to negotiate with the assignee. The other benefit, which has already kind of been mentioned, is this is a low publicity arrangement. It's not something that you have to file something in court. The whole world knows about it. It's public filing. And so everyone can scrutinize you about it. It's not done that way. It's generally done negotiating on the phone or via Zoom or some remote method or in person, but it's not done in a public forum. So there's a lot of flexibility that you can obtain by doing it that way. And then, of course, it relieves management of any further duties in the company. And so for management, it's a huge relief of a headache, as well as for secured lenders who don't know what to do with an asset. Once it's time to make a decision on what you do with the defaulting borrower, they can allow the assignment to occur to an assignee. He takes care of the marketing, and the asset gets sold, and the secured creditor gets paid. So these are some of the advantages that we see as being beneficial to the ABC process.
So we can cover this really high level because we've already hinted at a lot of this material. And frankly, there are some more interesting slides that we'll try to get to a little faster. So the way that the costs shake out for ABCs is that you've got the assignee fees, which are structured with an assignment fee and a success fee, as mentioned before. You've got your legal fees, the assignee's counsel, assignor and lenders are represented by counsel early in that process. And then you've got the sort of normal administrative and wind down costs that you see associated with any type of a liquidation scenario. We can move to the next slide, Matt. Legal schemes, I think that we covered this a little bit before. Some states have more court involvement, some states have less, some states have more statutory framework for how things run, and some don't, right? So, there are states where the statute or the court is going to tell you how to distribute claims and how claims objections are supposed to work, other details, and there are states where none of that is going to happen. And again, I refer you to the slides at the end of our presentation for the overview of how it works in the states where we practice. So let's move over to the best use.
So ABCs are a tool in the toolbox, along with bankruptcies, receiverships, Article 9 sales, all of that. These are the situations where we think they make the most sense. Simple capital structure. ABCs have lots of flexibility. We've talked a lot about these various sort of benefits. And so these are I think the areas here where it makes sense, to use an ABC tool as opposed to one of the other sort of insolvency tools that we've talked about. The largest obstacle sometimes to an ABC process being useful is litigation or foreclosure, predominantly because there's no automatic stay. And in those situations, the debtor will frequently reach for that bankruptcy tool to get the benefit of the automatic stay.
Sometimes the ABCs are difficult to pull off. It's not, you have different tools that secured lenders or other creditors can use. and sometimes it's not viable or it's not desirable to use an ABC. There's a lot of infighting between stockholders or between secured creditors. I'm involved in an ABC right now where you have 3 secured creditors all in different priorities, and everyone's claiming, the same collateral. We're still working. It's still working because people are level-headed and they understand the priority system and what they're supposed to receive. But sometimes there's not that cooperation. This is where an industry expert is very useful in convincing people that it makes sense to do it this way instead of fighting. When you have significant obligations from the government or priority claimants, and they just want to see you out of business, they're not going to cooperate with you. When you have certain contracts that you can assign through an ABC that are kind of valuable assets of the company, like licensing agreements for healthcare industries, you can't just assign those. It's a regulated industry, so you have to obtain a license from the government entity or contracts with CMS, Medicare, Medicaid. You can't just assign those contracts to a buyer. So that's where it makes it more difficult or less attractive to an ABC. When there's a lot of lawsuits out there, also not something where it makes it attractive, because these litigants sometimes want to fight with the assignee, even though the assignee has no liability. You generally try to get the ABC in place before there's a lot of litigation as an alternative to this form of claims resolution. And the ABC industry expert would be able to explain to these folks, look, we're assuming all the assets and we don't assume any of the liability. So litigation is only going to cost you money with your attorneys. And I don't know, Matt, what about the high value preference claims? What do you think about those?
Well, I think the issue on those is that some states like California, the assignee is actually vested with the ability to avoid preferences, much like a bankruptcy trustee could. So if there's a situation where the main source of recovery for creditors is going to be preference claims, an assignment case or an assignment may not be the right tool, because there is some case law in the Ninth Circuit, at least, that holds that state law preference laws are trumped by the bankruptcy code, and so they're not enforceable in federal court. So if you have, there's an opportunity for some gamesmanship there with defendants and preference claims trying to remove those actions to federal court to get out of liability. So in those situations, it actually may be better to do a bankruptcy. So how do the different alternatives stack up against an ABC? Turn this over to Alessandra.
So we're starting with Article 9 foreclosures because that's probably the closest call in comparison when you're thinking about what option might be right for a specific company and its assets. So here you've got, for ABCs, the advantage that the secured lender isn't held to that commercially reasonable standard or any other standard for an ABC, because it's the assignee who's the fiduciary selling the assets. You've got that neutral third party handling that. So that person's under the same microscope that a lender would be, not by statute and not by practicality. There's, as a practical matter, less attorney involvement in ABCs than there is in foreclosures, because there are just a few documents that really effectuate the process. Attorneys can be more involved when there are complications and wrinkles, but you have the assignee doing more of that heavy lifting. And as shown earlier, with the assignee's fee structure, it's a little bit more definite there than you might get with lawyers doing kind of handling various issues and things that might come up. So a benefit or a kind of advantage that foreclosure might have over an ABC is that the ABC requires the cooperation of management with lenders. So if that's a sour relationship, then it's, an ABC is not going to be an easy thing to pull off, and a foreclosure might be the most viable option. And same thing with, the need for board and stockholder approvals. You don't need that for foreclosures. If those are difficult to obtain, then an ABC might not be great.
Yeah, and Alessandra, another process I think most of you probably have seen or maybe more familiar with is the receivership process, which is can be a protection similar to the ABC process, where you come in and you take over the assets, protect them, sell them. The kind of big difference here is you have an ABC initiated by the company and not the creditor or a creditor coming in trying to claim that there's some waste going on or there's some interest or property right that needs to be protected. Because of that, you don't have the kind of the adversarial process in starting the ABC, as opposed to a receivership where, unless you have the right to obtain a receivership and you've got kind of consent and the debtor on board, well, that's kind of similar to what you have in an ABC. Otherwise, you're having to show that there's some property right being affected, that there, in some states, you have irreparable harm or some no legal remedy to protect yourself to get a receivership. Like I said, it's similar, the scheme itself, receiverships in Minnesota, for example, the ABC is run very similar to the receivership once you have an order in place that designates how you run and complete the ABC and how that process works. In Arizona, it's essentially the court has the same governance and power over the ABC like it has over a receiver, just not with the same, you don't have to have the specific order with all the rights set out that you have in a typical receivership. Other states, the assignee's duties come straight from the assignment deed and the assignment agreement. And so you don't have any court order at all. So depending on where you're going with that and completing it, you do have, again, back to the flexibility and the ability to push these things and roll them through. This provides a great option for that.
Chapter 11 bankruptcy. Chapter 11 bankruptcy is probably very familiar to many of you. An ABC is going to be less expensive than a Chapter 11 bankruptcy. Certainly, it's probably on par with the expense of a subchapter 5 case, depending on the assets that are involved. As we've discussed, it is lower profile. There's no court docket for people to go rummaging through to see what's going on. There's no set of schedules filed with the court, particularly in California, where people can see every asset that the debtor owns and every debt that the debtor had. They tend to be more efficient. ABCs tend to be more efficient than in Chapter 11 bankruptcy, largely because of the flexibility you have to run a process to fit the assets that are involved. Even in states where you have a court process, the ABC is going to be less intensive on the court side of things than a Chapter 11 bankruptcy is. In Delaware, for instance, and Alessandra, feel free to jump in. There are some key motions that are filed. You get appraisers appointed. You file a bond. There's an accounting, and if required by a buyer, for instance, you can even ask the Chancery Court for a sale order. But that is all much less intensive than the 363 or all the other sort of planned processes you would run into in a Chapter 11 case. Disadvantages compared to a Chapter 11, you don't get the sort of gold standard sale order, free and clear of liens. So that's sort of a big disadvantage, particularly if you have a sort of a very complex debt structure on an asset. Bankruptcy might actually be a better choice. And there's actually not really an option in an ABC for the management to stay in direct control. You could have sort of key people stay on to help advise the assignee. But the assignee is the one who's going to be making the decision, not the debtor's manager.
In Chapter 7, which is probably my less favorable tool, an ABC provides a lot of advantages over a Chapter 7 bankruptcy. Number one, in a Chapter 7 bankruptcy, there's generally little benefit to a company. A company doesn't receive a discharge of liabilities if they file Chapter 7. That's opposed to an individual, but we're talking about companies here. So companies don't have a lot of incentives to file ABCs. In addition to that, one of the biggest advantages of ABCs is that you have a little more control in the process as a borrower. You can, and even as a lender, you get to select the industry expert that Alessandra talked about, that you know is reliable and can market the assets, and you know that they're going to be able to work with the lender in terms of assignments, getting releases done, getting all that wrapped up. You can't force a Chapter 7 trustee who's protected by a court order and a huge statutory regime to do anything. They're going to do what they feel is best, regardless. That means that they're likely not going to operate the company. They're likely not going to market the company. They just want to get rid of everything, like garage sale almost quickly, and then they go into one of the biggest inefficient phases of Chapter 7 in my mind, which is they start investigating everything. It could be okay for in certain instances. I'm not telling you that isn't warranted, but in a lot of instances where you don't want to spend 2 or 3 years having a Chapter 7 trustee investigate every little thing, an ABC provides a much quicker process, a more efficient process. And you also have experienced industry experts that allow you to, that are familiar with the process of selling assets for more value, for a going concern operation, for, to get that, extra goodwill value that you wouldn't get in Chapter 7. Chapter 7 is almost, a death knell for people trying to collect on accounts receivables, on trying to, continue the operations of a company. That's just huge, enormous advantages of an ABC over a Chapter 7. Now, there's some risks in ABCs, and I'll let Matt talk a little bit about involuntary bankruptcy.
Right, and this applies either to Chapter 7 or Chapter 11. An involuntary petition, which is filed by 3 creditors that meet certain claims amounts, they can supersede an ABC. There is a fair amount of case law discussing about whether or not a bankruptcy court will abstain in certain fact patterns from hearing or resolving an involuntary petition in favor of the ongoing, insolvency process of an ABC. There is a statutory provision that allows an assignee to remain in possession if 120 days have already passed by the time the involuntary petition is commenced. So there is, it's not an ultimate sort of tool to overcome an ABC. There's also, the inherent risk in any involuntary petition of having to pay the other side's fees if you're unsuccessful. So it can be an appropriate tool if an ABC process has been started off and it's not appropriate, but there is a risk there. So for key takeaways, I think we're turning it over to Alessandra.
Yes, so thank you all for your attention today, and we hope that you learned something about ABCs. Our key takeaway for you is that ABCs should be considered as an option alongside foreclosures, receiverships, bankruptcies, or straight wind downs. Of course, the viability of an ABC or any of those options should be evaluated with counsel. We couldn't let you go today without hearing that point. So we're here for you. If you have questions, please feel free to reach out. We're happy and enthusiastic to talk about it. And thanks again.
Thanks, everybody.
One other thing, I just want to add one more advantage that we didn't talk about, is that if you're a lender or board, whatever, an ABC is less likely to sue these folks. They're looking to wind it down and sell a company. They're not looking to sue people because, again, they're looking to be efficient and to wind down the company as quickly as possible and sell it for the highest value. So that's generally attractive to people that are liquidating companies.
Yeah, very good point, especially in contrast to Chapter 7.
Well, thank you, Joe, Alessandra, Gabe, and Matt, and thank you to our audience for your attendance and attention. Please remember to sign the attendance sheet and return it to attendance@dorsey.com. And again, if you have questions for our speakers, you'll find their contact information in the presentation materials, or you may reach out to your usual Dorsey contact. I also wanted to let you know that on April 12th at 3:30 p.m. Central, Dorsey attorneys Aaron Bryan, Tom Kelly and Joe Liniak will present an updated review and forward-looking analysis on the recent failures and FDIC resolutions of Silicon Valley Bank and Signature Bank and the economic disruption that's been caused by those failures. So please look out for your invitation to that April 12 presentation. And thank you again, everybody.